My name is Barton Morris. I'm the principal attorney and founder of the Cannabis Legal Group. You can find us at cannabis-legalgroup.com. Today, I am going to discuss the 5 biggest reasons and biggest changes of the administrative rules that every licensee should know. The Marijuana Regulatory Agency is administered by, and they go by, administrative rules. These administrative rules were first introduced as like emergency administrative rules once we've legalized marijuana in 2018, and they set out some kind of quick ones in 2019. And then the MRA adopted its first final rule set in June of 2020. Well, now, effective March 7th, 2022, the MRA adopted the first major comprehensive changes to those rule sets. There was a public hearing in September of 2021, and finally now in March of 2022, they issued those changes. Those changes are significant. There's literally hundreds of changes that have been made to the administrative rules, but there's some small ones and then there's some big ones. Today I'm going to talk about the big ones. I can tell that these rules were precipitated by a number of things. I know that a lot of the disciplinary actions that were taken, because I had participated in many of them and represented a number of clients in them, I can see that they have changed the rules to address some of the issues, certainly with regard to disciplinary actions and alleged violations of the rules. I also see that they have taken recommendations from working groups, particularly the working group that I served on, which was the Diversity and Inclusion Work Group, otherwise known as a Social Equity Work Group. In that work group, we did put forth the idea of a Class A microbusiness license, and that is one of the new special license types that the MRA adopted in this new rule set. I will not be talking about the Class A microbusiness license in this particular video, as I'm going to reserve that particular subject for an entire video by itself. Right now, again, I'm going to focus on what I think are the 5 largest changes and the 5 most important changes that current licensees need to be aware of for their businesses, because they are significant and they're going to have wide-ranging impact, and if you ignore them, it's probably going to be to your detriment. The first thing I think is really necessary and important for current licensees to be paying attention to is Rule 420.112A. This governs licensing agreements and management agreements. What I know to be true is the fact that lawyers like myself and others sought to enter into agreements that really did try to avoid disclosure by some people that were perhaps didn't want to disclose and didn't want to be subject to background checks for whatever reason, entered into other type of agreements with the licensee in order to be able to realize their interest or their investment. And I see that the Marijuana Regulatory Agency, with these rule changes, have sought to flush those out. Now, they are permitting and explicitly authorizing these licensing agreements or management agreements, but what they're also doing is requiring their disclosure to the MRA. They have to be submitted to the MRA, and if they reflect that an individual is going to be either a manager of the company, of the licensee, or is deriving indirectly 10% of their either gross or net revenues throughout a particular 12-month period, they are going to require disclosure, and they're going to require that individual go through the pre-qualification process. This is very important for a number of licensees who perhaps have engaged in agreements with others, perhaps like, let's say for instance, an individual perhaps is the owner of some intellectual property, or the owner of the physical property in a particular licensee's business, or is even managing it through a management agreement. and they're deriving income from that, right? So like if you own intellectual property, for instance, and you're licensing it or selling it to the licensed entity, you're deriving income from it. Well, those agreements now have to be disclosed. They have to be delivered to the marijuana regulatory agency, and the regulatory agency has to approve them. As those rules are executory in nature, and I believe that the MRA wants to see them. So this is really going to frustrate a number of licensing agreements and management agreements, and a lot of people that were trying to seek from not having to disclose or going to have to disclose. It's definitely something that I think that a lawyer should probably review in an effort to either one, figure out some other way that is consistent with the rules, of course, or to provide disclosure and be compliant with the rules, because otherwise there's going to be some non-compliance, and of course that comes with disciplinary action and formal complaints to be filed. The second biggest change that I have identified in these new administrative rules is really related to the first change that I talked about, which is the disclosure of management and licensing agreements. Well, the second biggest change is Rule 420.203, which is a licensee's requirement to maintain accurate financial records for each individual license. These financial records will often disclose where the money is going so that the MRA can identify those whom may be in receipt of 10% or more or in excess of 10% of the gross or net revenue, and along with the disclosure of the management or licensing agreements will identify those who have to disclose. I know my clients often complain about the fact that, or at least it becomes a little bit more frustrating when they know, particularly when they have to comply with the annual financial reporting. There's a lot of documents and data that has to be disclosed and evaluated, and when they have to do it per license, it becomes even a bit more cumbersome. That's what 420.203 requires. For each license, a licensee has to ensure that and maintain everything, including cash logs, sales records, purchase of inventory, invoices, receipts, deposit slips, canceled checks, employee compensation records, tax records, and bulk financial deposits and transactions. They have to keep those for a period of 4 years for each, and separately for each license. And so a cultivator, for instance, might have multiple growers licenses, and they have to keep those transactions and those records separately for each license. And so a co-located license or licenses that are stacked, that those licensees are going to have even a bit more of a difficulty of a time doing that. So, but that is going to be something that is going to require some significant changes in a licensed entity. Also important and kind of related to that is now the MRA is requiring that every licensee maintain standard operating procedures. Now, this might not be difficult for many operators, as I know that many licensees are already maintaining standard operating procedures. But what I also know is that many of them are not. It's important that the standard operating procedures cover all issues with regard to compliance with the new administrative rules and the act that that particular license was issued under, whether that be the Medical Marijuana Facilities Licensing Act or the Michigan Regulation and Taxation of Marijuana Act, and the rules. So every licensee is going to have standard operating procedures. Many of them do, but again, many don't. So if you don't have SOPs covering your operations, if you're a licensee, it's something that you're going to have on the premises, up to date at all times. The fourth biggest change that I have found in the administrative rules concerns the operation of marijuana sales locations and their contactless or limited contact transactions, often known as like drive-through transactions or parking lot transactions. Of course, everybody is familiar with the fact that during COVID, these transactions became much more common. and permitted because we had to cut down on contact situations. Now the MRA has embraced that situation, embraced those transactions, and have now made a rule permitting them. But it's important to understand that the marijuana business location narrative that had to be filed with step 2 of the license application has to be amended in order to illustrate where these transactions are to be taking place. I know that many licensees and retail operations were performing these operations in their parking lots, but that parking lot wasn't contained within their business location narrative or the floor plan, the facility plan that had to be filed with the MRA. So it's necessary that those plans have to be amended. If a licensee, if a retail licensee is still engaged in this activity, and most of them are, if not every single one that I've seen is continuing to do so, and I think with a lot of benefit, and there's a lot of benefit to the consumers, there's a lot of benefit to the licensees. The rules explicitly permits licensees to be able to take orders and even take payment over the phone or through the website, where a consumer then can come and show up and then it just be delivered to their car. It's a great thing, and perhaps even a positive thing that COVID may have created in the industry. But it is now explicitly permitted, but it does have to be complied with in the rules, and it does also require a standard operating procedure. You have to have a standard operating procedure that is covering all of the issues that are related to how those transactions take place, and in accordance with ensuring compliance with the administrative rule. This particular administrative rule is 420.207A. Labeling became another issue of significant importance, and so that is the 5th thing that I believe licensees have to comply with to ensure that they are maintaining compliance with the new administrative rules that were just made effective on March 7, 2022. And one of the major issues, I think, one of the new issues that has been created is the fact that now all of these products have to have expiration dates. And these expiration dates have to be valid. But also important, this rule reflects that if the product is expired based upon the expiration date, the product then has to be destroyed within 90 days after that expiration date. The rule explicitly prohibits a licensee from changing the expiration date. So now what I think that the MRA was believing is that there was expired product that was still being distributed. Now there is an explicit rule that the expiration date has to be on the product, and if it is past the expiration date, that product has to be destroyed. So that can have some wide-ranging changes with respect to inventory procedures with retail operators, and also their ordering procedures are probably going to have to be changed a bit as well. I know that I said that I was going to stick with 5, but I think as long as I'm doing this, I might as well comment on a couple other changes which I think are important. Internal analytical testing is now explicitly authorized. This was something that was already happening. A lot of licensees were doing their own testing. They want to do their own testing. Cultivators, processors. By the way, they've changed that terminology now. They're called cultivators and producers. The licensees were doing their own testing. They want to look and see how good their product is testing, and whether it's going to pass testing. And just for their own purposes, they want to ensure that their product is conforming to the standards that they're setting forth. And so licensees were doing their own testing. That is explicitly authorized now, but also now the MRA requires it to be pursuant to this rule 420.207A. 20.214A, which requires that a space, in order to perform that internal analytical testing, must be fully partitioned from all other licensed activities at the marijuana business. It has to also conform with the security requirements, and so all of the security cameras have to be on that particular location in conformance with 420.209, which is the security rules. Only one product from each licensee is able to be tested at one time, and so if a cultivator actually has multiple licenses, only product from one of those licenses can be tested at one time, and you can't store anything in that same area too. As many people could imagine, it's very likely that this was also a storage area where they're also performing independent laboratory testing or internal laboratory testing. That's no longer permitted. Nor is it permitted to be in the same area as perhaps the production of the other operation. It has to have its own separate, individual, fully partitioned area for internal testing. And then there were some rules with regard to product returns and adverse reactions. Now, a licensee shall notify the agency within 1 day of becoming aware of whether the licensee was aware of any adverse reactions to any cannabis, and then, of course, product returns is now permitted as well. The rules before didn't actually explicitly permit a retail licensee to be in receipt of somebody returning some product. It only permitted licensees to actually deliver the product to a consumer but not actually receive it. And so now they're explicitly permitting that as well. Like I said, there are a lot of changes in these administrative rules, particularly as it also relates to safety compliance facilities, which is going to also be the subject of another video. But I believe those are the largest requirements that licensees really have to pay attention to. If a licensee has any questions about how to apply these rules or interpret these rules to their own facility, of course, we are available. The Cannabis Legal Group attorneys are available to assist with the interpretation of the rules, compliance with the rules, with documentation and writing SOPs and writing compliant documents necessary to comply with these rules, but also with respect to reviewing management and licensing agreements and submitting those to the MRA as well. We've already been doing that this week, actually, as it relates to the necessity to do that. So if anybody needs us, of course, you can reach us at cannabis-legalgroup.com. Thank you for watching, and stay safe.